Disabilities Act means a form that would render the information readily accessible by the person having regard to the special needs of the person, and regulations may prescribe circumstances in which the requirements of subsection 2D shall be taken to have been met. Provision in square brackets is just to allow for some delineation of what is meant in relation to what could constitute intelligible form for a person with a disability. So if that's okay, we could remove the square brackets. Yes, I made a correction. Duplication in the list of amendments. So the reference there to the insertion of a subclause 9 in clause 6 should be deleted. Right. Okay, so we delete, the next substantive amendment is to delete existing clause 9, and we have substituted a new clause 9 which deals with consent to processing, which is set out there. Right, so inconsistent with what we had done before, here in the new 9(1)(b)(2), where it reads, an individual to whom the data subject delegates the right to give or withhold the consent to processing, it should now read, delegates in writing in such form and manner as may be prescribed. The right to give or withhold consent to the processing. In 9(3), where it reads, in the case of a minor, it would now read, in the case of a minor subject to section 5A1, a parent or legal guardian of the minor. Right. Okay. Yes. Okay.
CBC, I'm just wondering whether the term legal guardian in this provision takes the meaning applicable under the CPR, or it's just someone who has care and control of the minor?
It would be somebody who has care and control. So we are renumbering the existing clause 11 of the bill and inserting a new clause 10, which deals with consent required for direct marketing. And the provision is set out there. The next substantive change is to clause 15, where amended subsection 2. So it would now read, subsection 1 does not apply to A, processing, or B, data controllers of a particular description specified by the minister after consultation with the commissioner for the purposes of this section by order published in the Gazette and subject to affirmative resolution. Being processing which it appears to the minister is unlikely to prejudice the rights and freedoms of data subjects. And then the existing subsection 3 is deleted. Where? Thank you. Just to go back to clause 10, the new inserted clause 10, there was a provision in square brackets in subsection 6. Right, so in this act, direct marketing means to approach a data subject in person or by any means of communication, whether electronic or otherwise, for the direct or indirect purpose of A, promoting or offering to supply, in the ordinary course of business, any goods or services. So we just wanted some confirmation that the words in the ordinary course of business were appropriate in the context. Yes, we can leave it. All right.
Forgive me, but just thinking as a layman now, what would constitute something that is not in the ordinary course of business?
Well, the first thing that would come to mind would be something that perhaps somebody who is not ordinarily a business person, for example, somebody who might just be offering or trying to raise money for a one-off, maybe charitable event like a fun run or something, might be calling somebody on a list. And so that would not be in the ordinary course of business. And if anybody has any other examples. Okay, so clause 15. The new, I had gone through those already, so the next change would be in clause 18, where we were deleting the reference to a penalty in the circuit court. So the provision in subsection 3 would now read, a person who commits an offense under subsection 1 shall be liable upon summary conviction in a parish court to a fine not exceeding $2 million or to imprisonment for a term not exceeding 6 months. Clause 20. At 19. I think, yeah, it's not. Right. So in clause 20, we're inserting a new subsection 6. Which specifies the categories for which a data controller is required to appoint a data protection officer. So in clause 21, the obligation is now on a data controller falling within subsection 6 to appoint an appropriately qualified person to act as a data protection officer, responsible for, in particular, for monitoring in an independent manner the data controller's compliance with the provisions of this Act. And a data controller falls within subsection 6 if the data controller, A, is a public authority, B, processes or intends to process sensitive personal data or data relating to criminal convictions, or C, processes personal data on a large scale. But a data controller who processes personal data only for the purpose of a public register, or who is a non-profit organization established for political, philosophical, religious, or trade union purposes, does not fall within this subsection. Clause 21.
Apologies, Chair, members. Going back to clause 26, the new amendment, the amendment captures a decision of the committee. However, on review, we are concerned that there may be a lacuna that is created, because if the data controller doesn't fall within the list A, B, C, and is not a not-for-profit organization established for the purposes listed, then the question would be asked, do I need to appoint a data protection officer? So we wanted to just flag that, because we believe that there may very well be data controllers that who should be required to appoint a data protection officer or not, but they wouldn't know where they fall because they're not a public authority, they're not processing sensitive data, they're not processing on a large scale, but yet they're not political, philosophical, religious, or trade union. So they're just kind of in the middle wondering, what should I do? So we're wondering if in those cases there should be a requirement for that data controller or those data controllers to seek clarity from the commissioner as a solution to what is potentially an issue.
So what's an example of that data that is not sensitive personal data?
But because of the list, so for example, a club which is not established, which a Kiwanis club, or for example, or Rotary Club, wouldn't fall within that list. They're not established for political, philosophical, religious, or trade union purposes. They're just a club. It could be a football club, as an example. But so they don't fall within this description. So they wouldn't be sure whether or not they would be required to appoint a DPO.
Would they process or intend to process sensitive personal data?
Yes, so they would be processing personal data, but it might not be sensitive, nor is it on a large scale, because it might just be,
no, but
12 people.
If let's say they go on this club and they collect my name, my address, my phone number,
but that's not
my
sensitive.
email, that's not sensitive?
Sensitive data as defined in legislation would include health records, information about your philosophical, religious, and those beliefs. So that club, and I mean, the example of a football club, I think, is a relevant one, wouldn't know where they fall or whether or not they would be required, even though they are collecting data, but just not sensitive. They're not a public authority. It's not on a large scale, but their non-profit organization is not established for these reasons. So I don't know if the solution is to add social. I don't know what, but we're just raising it because with the committee for consideration, because there is a potential for a lacuna.
I just wondered, and I take your point, Ms. Murray. I just wondered whether maybe a catch-all provision, well, not catch-all, but maybe a provision CPC to the effect that, or such other areas as may be prescribed by the minister, whether that would solve the problem that Ms. Murray has.
I would think, Ms. Murray, that they would have the option to inquire as to whether or not, right?
They're empowering the commissioner to be able to determine on a case, in those instances, as a case by case might be a solution. But otherwise, yeah. But they should be required to ask whether or not there's a need.
Hi, there's a car blocking someone that wants to leave. License plate number 4422HP. It's a Ford G4.
Perhaps we could include in the new subsection 6 a new category D, which would read D falls within a class prescribed by the Commissioner by notice published in the Gazette as being a class of data controllers to whom subsection 1 applies. So that would give some discretion. Okay. All right. Clause 21 is being amended in subsection 2.
I'm so sorry. Ms. Grant, can you just repeat so that we can take a note? It was a little fast.
Sure. New 6D. So just to read from the chapeau, a data controller falls within this subsection if the data controller D falls within a class prescribed by the Commissioner by notice published in the Gazette as being a class of data controllers to whom subsection 1 applies. Okay. Clause 21 is being amended in subsection 2 to include a requirement to be an offense for a person to fail to make a report or notification required under subsection 3 or 5. Subsection 3 is being amended to include a provision for enabling the Commissioner to prescribe the form and manner in which the report should be made, and for the report to be made within 72 hours after becoming aware of the contravention or security breach, as the case may be. Subsection 5 is being amended to read, where a contravention or security breach mentioned in subsection 3 poses a real risk of significant harm to a data subject, the data controller shall, upon becoming aware of or having reason to become aware of the contravention or breach, notify the data subject of A, the nature of the contravention or security breach, B, the measures taken or proposed to be taken to mitigate or address the possible adverse effects of the breach, and C, the name, address, and other relevant contact information of its data protection officer in such form and manner and within such time as shall be prescribed.
Chair, we're proposing an additional amendment to the list of amendments for clause 21, and that's just in subsection 4B to insert the word personal before data.
Sorry. Yeah. Okay. In clause 23, subsection 1 is being amended.
Sorry, just a moment, Chair. In clause 22, subsection, what subsection is it? Subsection 7B, where it has in such other circumstances as may be prescribed, I recall a decision of the committee for it to be subject to affirmative resolution. So I'm not sure if anyone else has a recollection.
It's dealt with in the regulation making section, which is now, now clause 74, previously clause 76, a new D was added to provide for that regulations under section 22.7, prescribing additional circumstances in which a data controller is not obliged to disclose to a data subject the information referred to in section 22.4. So clause 23.
We've lost the quorum. So I guess we have to meet again. Next 20th? Or 2 p.m. Let me check and see. All right. We will meet again next Thursday, February 20th at 2 p.m. I know. I was hoping today would be the last day. Next Thursday at 2 p.m., February 20th. And we'll begin at clause 22? 23. Clause 23.
Chairman, just for the record, I'd like to apologize for Senator Scott Motley. She has a meeting that she could not get out of.
Meeting now stands adjourned.
You never put up a fight, no. Paradise come, just know me like we knew we never had to say a word, not a sound. Silence, you baby. You never put up a fight, no. Paradise come, you just know me like we knew we never had to say a word, not a sound. Silence, here it is. You never put up a fight, no. You nobody put up a fight, no. Paradise Plum, and keep it locked to PBCJ.